Okay, good morning, everybody. My name is Judge Kim Teresa Malika. You're in First Appearance Magistrate Court. Today, you're going to be informed of the charges, and we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything is being recorded. You have a right to remain silent. If you also have a right to an attorney, we have, I believe, Mr. Romero or a public defender at the main jail, and we have Mr. Reedy to my right in the courtroom. And we also have Eric Linder from the State Attorney's Office. All right, so let's call the first case, Dustin Turner.
Good morning, Judge.
Good morning, Mr. Romero. How are you?
I'm doing well.
Okay. All right, so Mr. Turner, you have an out-of-state hold for a no-bond hold for a felony case. Court does find probable cause. We'll see you in extradition court Tuesday or Thursday at 1 p.m. This is a failure to appear in Pennsylvania from a strangulation charge. Thank you, sir. Good luck to you. Colleen Kearns.
Morning, North Broward.
Okay, Madam Clerk, that was the first one, just so you know. Okay. All right, Ms. Kearns, you have a capious misdemeanor for trespass property, other structure. Court does find probable cause for
Ms.
the
Kearns would like
arrest.
to resolve this today, Judge, if that's possible.
State?
Good morning, Your Honor. Carly Quintana on behalf of the state. The offer is withhold court costs, no return to 321 West Atlantic Boulevard, Pompano Beach.
Okay, I'm sorry,
321 West Atlantic Boulevard, Pompano Beach.
And what is that?
One moment, Judge.
Did you understand the offer, Ms. Kearns?
I just can't return and there'll be court costs?
Yes, and no conviction on your record. Is that what you would like to do?
Yeah,
Do you know where this place is?
yes,
Then you know not to go back there?
yes.
You know what happens if you go back there?
I get arrested.
That's right.
Your Honor, the address is the parking lot. That's where she was picked up.
What's her priors?
She has no felonies on her record as far as I understand, Judge.
Your Honor, she has no other trespass priors.
Says they've been trespassed from the property multiple times. Says
I've only been
that
trespassed once.
stated the couple
don't
were
say
a
anything,
nuisance
Ms.
and repeatedly came to the property, despite being trespassed multiple times.
I can't hear
So
it.
state, what's your offer?
Withhold court costs and no return.
Okay, I'm not gonna do a withhold. I'll do an adjudication, time served.
So it will
And
be
no
an
return.
adjudication, Ms. Kearns. Do you understand that?
What does that mean?
It means you'd have a conviction for this on your record.
Okay,
But you really can't go back there,
okay,
okay? Because next time it probably won't be time served.
okay,
All right, raise your right hand. Do you swear and/or affirm to tell the truth?
yes,
Okay, put your hand down. Is your name Colleen Kearns, Kearns?
yes,
It's my understanding you wish to resolve this case today and give up all your rights to a trial?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
How do you want to plead to trespass, property, other structure? Guilty, not guilty, no contest.
Guilty?
You feel that pleading guilty is in your best interest?
I mean, is that what I'm doing?
Are you pleading guilty today?
Is that what I'm doing?
Well, if you want to resolve the case, yes.
Yeah, yeah.
Okay.
Okay, you have to be certain about it. Do you feel that
Yeah.
pleading
yeah.
guilty is
That's-
in your best interest?
Yeah.
Okay. And you understand that if you return to the 321 West Atlantic Boulevard, Pompano Beach, that you're going to be arrested again, and then you'll have to come back here. Do you understand that?
Yeah.
Yes?
Yes.
All right, court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea, adjudication, time served, $293 in court costs, 6 months to pay, partial payments accepted, no return to the address I just stated. You have 30 days to appeal the legality of a sentence to the court. If you can't afford an attorney, one will be appointed. Does she need a place to live or services?
Judge, I talked with her about the CRC program. She said she's interested in it, but she's going to go there on her own.
Okay, thank you.
And remember, it's on 441, just south of Commercial Boulevard on the east side of the street.
Okay.
Thank
Okay,
you,
check
ma'am.
it
Good
out.
luck to you. Chantel Dube? Oh, there is. Okay. Rakisha Samuels?
Well, I believe, Judge.
Thank you. All right, Ms. Samuels, good morning, ma'am. How are you?
Fine.
All right, you have an ad charge, count 4, fraud, misrepresent self, commit personal ID, $1,000 bond. Count 5 is petty theft, second degree, first offense, no bond required. The court does find probable cause. The court's going to order no victim contact whatsoever with Kayla Rose Miller.
Who is that?
Okay, you can ask the public defender, ma'am. It's the alleged victim in the case.
I don't even know who that is.
Judge, I'd ask you to leave the bonds in place where they are. Ms. Samuels has a no bond violation of probation hold on count 3.
All right, so court will order a no bond hold. Court will leave the bonds in place because she has a no bond hold. Thank you, ma'am. Good luck to you. Kanishka Forbes?
Present Judge at Maine.
Thank you. Okay, Ms. Forbes, you have driving while license is suspended. It's a habitual traffic offender. It's a felony charge. Court does find probable cause. Bond is set at $750. What say you, defense?
Judge, in speaking to Ms. Forbes earlier today, she did advise me that she spoke with her family, and her family was going to do everything possible to bond her out. So I'm going to be asking the court at this time, could you see if her bond's been posted?
Devon's checking from confinement.
Thank you, Judge.
Okay, thank you. It's not showing as of yet.
And that was my worry, Judge. And speaking to Ms. Forbes, she said they were going to do everything possible. Something may have happened where they weren't able to obtain the funds. So I'm going to be asking the court to consider releasing her on pretrial release. I'll see if the state has an objection before I proceed.
State has no objection.
Okay, per state and defense. Does she want to call in 7 days a week?
Let me ask her, Judge. Judge, we'll opt for option number 1 where she'll call in 7 days a week.
Okay, so pretrial, no bond is required, 7 days a week call in. She doesn't have to report after court. She doesn't have to report during the month, but she does have to report one time.
Within 24 hours?
Yes,
Release.
yes.
Thank you.
Okay, thank you.
Thank you, ma'am. Good luck, ma'am.
Laura Strauss?
Ms. Strauss, come on up, please.
Good morning, Ms. Strauss. You have grand theft between $300 and $5,000. Bond set at $1,000. Court does find probable cause. Mr. Reedy, as usual, if you have a probable cause objection, let me know, okay? All right, court's gonna order no return to the Home Depot at 1151 West Copans Road. What say you, defense?
Judge, in speaking with Ms. Strauss, she informed me that this is her first contact with the criminal justice system.
Is that
The
true,
registered
State?
voter, we're gonna be requesting
Yes, Your Honor.
ROR.
Okay, ROR. Good luck to you, ma'am.
Thank you.
Hold
Look
on a
out for your
moment,
note.
ma'am.
Should be
Let me
coming
just,
3 weeks.
ma'am, hold on.
Yes.
2350 Northeast 14th Street, 504.
Yes.
Okay, thank you. Good luck to you, ma'am.
Good luck, ma'am.
Thank you.
Christine Meziux. Hello, Miss Meziux. You have driving while license is suspended as a habitual offender, $750 bond.
I'm sorry, Judge.
That's okay. No problem. You have a driving while license is suspended habitual traffic offender, which is a felony, $750 bond. Counts 2 and 3 are probation violations. You have no bond holds. Court does find probable cause. What say you, Mr.
Judge, I'm
Romero?
gonna request, since considering the outstanding charge here in Broward County is a nonviolent in nature, I'm gonna request an ROR so that Dade County can pick her up.
What happens when she's in jail in Dade County and she has a court date and then she has a capias and then they have to go back to the division and explain it to them? I'm just saying, I don't care, but.
Judge, at this time, I can't answer those questions. There's a lot of what ifs, but I know at this time to help eventually get her trying out of custody, she's gonna have to go to Dade, so I'm just trying to speed up the process considering this charge isn't filed and she's just arrested on it.
All right, I'll
Also,
set
she can tell
100.
her public defender in Dade County that she has a pending charge in Broward, and they can communicate with our office and make sure that she doesn't get a capias issued for her.
Okay, I'm gonna set $100 bond. She also has, I'm just advised, she has $100 bond, an Orange County hold. Thank you, ma'am. Good luck to you. $100 on that one. Misty Elsner,
North Broward.
thank you. Okay, Miss Elsner, good morning, ma'am. How are you?
Fine.
All right, you have a grand theft between $300 and $5,000. Bond set at $1,000. The court does find probable cause. Court is gonna order no victim contact, direct or indirect, with the alleged victim with the initials AD. This is the one with the TSA. All right, State, what say you?
Your Honor, state would ask for the bond to remain in place. No victim contact.
Okay, there's no victim contact whatsoever, ma'am, with the alleged victim with the initials AD. If you need to know who it is, you can ask the public defender's office or attorney who's representing you today. What say you, defense?
Judge, I don't think Miss Elsner's gonna be able to post a $1,000 monetary bond. She does have a place to go. She was in the life recovery program in Palm Beach County, and she says that she can return to that location. But I do not believe she's gonna be able to post any kind of monetary bond. She also has some medical issues that concern me as to whether or not she's going to get appropriate treatment in the Broward County Jail. Not to minimize anything, but this does seem to have been a crime of opportunity. Not that that excuses it. She has provided me with the name and number of her sister, but unfortunately her entire family is in Ohio, so they are not local. I don't know if they're gonna be able to make arrangements to bond her out from Ohio. Ms. Elsner did not seem to be overly optimistic about that prospect. I'd ask the court to consider releasing her on pretrial release.
She was able to arrange to get a flight back home. And that costs something. They don't give those away for free. So
Tell me, does she, can you tell me if she has any priors
she does out of
nationwide?
Out of Ohio, theft,
Was that a felony or misdemeanor, do you know? Can you tell?
looks like a misdemeanor, 09,
Okay,
wanton operation of a motor vehicle, looks like that was pled down from DUI in 08. Attempted possession of cocaine, operating a motor vehicle while intoxicated, 03.
all right. I'm gonna do standard pretrial supervision, but I am gonna have her call in 7 days a week, report once a month in person. She doesn't have to report after she sees her judge.
Thank you, Judge. Misty, there should be a map right underneath the podium there. For you to get to pretrial release, you need to report there within 24 hours of your release from the jail.
And if you don't, ma'am, you're gonna have a warrant out for your arrest.
Maybe
Make
the
sure
I
you-
deputy-
don't, there isn't a form.
It's a map, it shows directions. Deputy at
There's-
North Broward,
There's no map. Okay, map. Does that mean
I know she already says she lives in Ohio, but she's gonna reside here in Florida, or is the court giving her permission to travel back and forth
she has permission to travel back and forth.
to Ohio?
Yeah,
Okay.
Make sure you don't miss court, Misty.
Okay.
All right, check
And
your
when
court
is
dates.
court?
Huh?
When is court?
here's
haven't
the
set a
next
court
thing,
date for
here's
you
the
yet.
next thing we have to talk about. Her address is 237 Linden Avenue, Dayton, Ohio. Is that your mailing address for court?
Yeah.
Okay, make sure you can also look on the internet, ma'am, don't miss it.
Okay.
Good luck, Ms. Elsner. Good luck, Ms. Elsner.
Thank you.
Stephanie Shiro. Okay, Ms. Shiro, you have grand theft between $300 and $5,000. $1,000 bond is set. Count 2 is possession of anti-shoplifting controlled device countermeasure, $1,000 bond. Court does find probable cause.
Judge, I have a probable cause argument as to
Sure.
count 2. The possession of the anti-shoplifting control device, I did not see the mention of it in the probable cause affidavit.
State?
No objection, Judge.
Okay, per state and defense, no PC. On count 2. Okay, what say you? $1,000 bond, no return to Coles, 9001 West Atlantic Boulevard, Coral Springs.
Judge, Ms. Shiro is not going to be able to make a monetary bond at this time. She did provide me with the number of a friend of hers that she believes she can stay at his house. I called and left a message. I have not yet heard back from him. But she does appear that she can stay there. She seems pretty confident in that. I think her priors consist of another grand theft. I don't think she has any other priors. I'd ask the court to consider pretrial release.
Your Honor, pretrial services.
Can you hear, ma'am? Can you hear pretrial services?
Yes.
Ms. Shiro was placed on pretrial on September 10th for case number 18011-072 CF10A for count 1 grand theft greater than 300 less than 5,000. Counts 2 and 3 retail theft 300 at multiple locations. And we're requesting a revocation as a result of this court finding probable cause in this case.
Okay. When was she arrested for this?
She was placed on pretrial back on September 10th.
And she's out in Coles. Okay.
Your Honor, I've had
Don't
some
say,
problems.
don't say anything, Ms. Shiro.
Anything further?
Yeah, Judge, I think that's the extent of her criminal history, Judge.
All right, well, she's out on pretrial, so I'm gonna revoke her pretrial.
And Your Honor, I just want the court to be aware, I believe, I could confirm, but I believe she might have been with her co-defendant in this case, on that case as well. He's on the docket later on also. And that is Anthony Sinanti.
Okay, note co-defendant contact with Anthony Sonate,
Okay,
Sonetta.
CINNA.
yeah, okay.
Spell it again, I'm sorry.
CINNANT.
Okay. And this one just has one charge, Madam Pretrial?
She has 3 charges. Count 1 is the grand theft.
I see, 2 and 3. All right, so the court's gonna revoke her pretrial in case number 18-11072, CF 10A, $1,000 bond on 1, 250 on, oh, you know what, I'll ROR on 2 and 3, so she has a total of $2,000. Thank you, ma'am, good luck to you.
Thank you, Judge.
Lillian
I will
Bentley.
call Ian again.
Okay, Ms. Bentley, you have driving while license is suspended as a habitual $750 bond. Court does find probable cause.
Judge, I'm going to ask you to release Miss Bentley on her own recognizance.
Okay,
She has been living in the same location for the last 2 years. She lives with her mother. She is a medical support assistant. She's had that job for the last 8 months. She's in the last year of her master's degree at Nova, and I believe her entire criminal history consists of suspended license charges, and we had a talk about how important it is that she get her license in order before she drives again. How long have you been living here, Miss Bentley, in Florida?
I was born in Florida, but then I left to go to the military, and I came back in 2010.
And what branch of the military were you in?
The Navy,
What type of discharge did you receive?
honorable,
what was your rank?
E4.
Okay.
She sounds like an excellent candidate for an ROR, Judge.
Is your mailing address 5710 Lakeside Drive, 715?
Yes, Your Honor.
All right. State, any objection?
No objection, Judge.
Okay, ROR. Ma'am, you're not to drive until you get a valid license, do you understand?
Yes, Your Honor.
I know that's the law and you're required, but to do it anyway, but I'm gonna tell you and make that an order of the court. Thank you.
Thank you.
Abigail Rowe?
Mr. Lane,
Abigail Rowe, I'm sorry, did you say where? We find probable cause previously, I think we did. All right. Joseph Sinclair,
Conti, Your Honor.
good morning.
Good morning.
All right, you have an ad charge, driving while license is suspended. Court does find probable cause, bond set at $1,000.
Judge, I'd ask you to leave the bond in place. Mr. Sinclair has a no bond hold for a violation of probation on count 4.
What's the no bond hold for?
I believe it's a violation of control.
Okay. Thank you. Terrence Mack, come on up. We'll do you right after
Senior
this next.
President Judge at Maine.
Okay, and then we're gonna do, the Spanish interpreter cases. Okay, Mr. Mack, you have an ad charge for trespass to structure or occupied conveyance. Court does find probable cause. Judge Hurley set bond at $1,000. What say you, defense?
Mr. Mack has a no bond hold for a violation of probation on count 2.
Is it a violation of probation or a violation of pretrial?
Oh, this is maybe the pretrial one. Hold on.
Yeah.
Okay, raise your right hand. Do you swear and or affirm to translate from English to Spanish, Spanish to English to the best of your ability?
I do. Good morning, Your Honor.
Hello.
Solange Sands, Saenc.
Thank you.
You're welcome.
Judge, if it's not a probation case, and speaking to Mr. Mack earlier today, he wishes to resolve it. I did go over as far as the criminal score sheet, how this could potentially affect his sentencing guideline. However, he still wishes to resolve it and get this case over with today.
State.
The offered adjudication, time served, Your Honor.
If it's not a probation case, he'll accept the state's offer, Judge.
Let me just double check. It is a violation of pretrial.
Say, can I have that back for a second? Hey, I'll do it, but he's not to return. He was trespassing. He was told he was harassing customers inside a McDonald's, making a verbal disturbance, yelling and screaming at customers. So he's not to return to the McDonald's at 300 West Hillsborough Boulevard, Deerfield Beach, Florida. You can explain to him, Mr. Romero, what happens if he returns there.
I did talk to him, Judge. He's aware of the consequences, and he still wishes to resolve the case, accept the state's offer. He's going to assure the court he's not returning to that location.
All right, raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, your name is Terrence Mack, M-A-C-K?
Yes, ma'am.
All right, you can put your hand down. It's my understanding you want to resolve your case today and plead guilty or no contest to trespass, a structure, conveyance, occupied?
Yes, ma'am.
All right, anybody forcing you to do this?
Uh-uh.
Is not an answer. It's either
No,
yes,
ma'am.
no, I don't know. No?
ma'am.
Okay. All right, you've had enough of time to speak to your attorney, Mr. Romero?
Yes, ma'am.
You understand that you're giving up all your rights to a trial, and if you want, I'll release you on your own recognizance, and you can come back and fight the case. You don't have to admit to it today. Do you understand that?
Yes, ma'am.
All right, so how do you want to plead? Guilty, not guilty, no contest?
No contest.
Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea, adjudication, time served, $293 in court costs, partial payments accepted, no return to the McDonald's. You have 30 days to appeal the legality of a sentence of the court. If you can't afford an attorney, sir, one will be appointed. Thank you, good luck to you. Who are the Spanish cases today?
Judge, here at Maine, it's going to be on pages 13 and 14, and the gentlemen's names are Mr. Alex Ferrer and Mr.
Let me get the first one. Alex,
Ferrer.
hold on, and then it's, okay, I got him.
Ferrer, and right after him is Mr. Abel Peguero Estrada.
Okay. Okay, who was the one at Conti? What page was those persons?
13, 14.
Okay. Mr. Reedy?
Page 18, Arenas Mejia.
Anybody at North Broward need an interpreter?
Oh, ma'am.
All right, anybody at Paul Ryan need an interpreter? All right. Alex Ferrer? Is that your name, sir?
Señor, su nombre es Alex Ferrer?
See.
Yes.
All right, and for the record, Ms. Lange has been previously sworn. Sir, you're charged with, this is page what?
Page 13.
13. Page 13, so you can follow.
Para que conste en el acta, la intérprete ya prestó juramento y vamos a buscar los cargos en la página 13.
Okay, sir, you have possession of counterfeit credit cards, two or more, $1,000 bond, court finds probable cause.
Su cargo es que usted tenía en su persona tarjetas de créditos falsificadas, tenía 2 o más. Tiene una fianza de $1,000 y la corte decide que existe motivo fundado.
Judge, speaking of Mr. Ferrer, he advised me this is his first arrest. If the state can confirm that, we'd be asking for an ROR.
Después de conversar con el señor Ferrer, me ha contado que esta es primera vez que se ha sido arrestado. Entonces, si el Estado confirma que esto es verdad, vamos a pedir que lo dejen en libertad bajo su propia palabra.
How long has your client lived here?
¿Cuánto tiempo tiene de vivir aquí?
Okay, I think you're saying 5 years, your mic is off.
Oh, I'm sorry. I'm sorry, it was my bad. 5 years, Judge.
That's what I thought.
Sí, 5 años. Tenía apagado el micrófono.
Your Honor, the state would ask that the bond stay in place.
El Estado pide que quede la misma fianza.
Okay, ROR. Thank you, sir. Good luck to you.
Queda en libertad bajo su propia palabra.
Abel Peguera Estrada. Page number, please.
Page 14, Judge, Senor Peguero.
Do you have it, Mr. Lange?
I do, thank you, Your
Thank you.
Honor.
All right, Mr. Estrada, you have possession of counterfeit credit cards, two or more, $1,000 bond. Unlawful conveyance of fuel, $1,000 bond. Count 3 is a probation violation, no bond hold. Court finds probable cause.
Señor, usted tiene un cargo de tener en su persona tarjetas falsificadas, tener una o más. También tiene un segundo cargo de transporte ilegal de gasolina. Y su tercer cargo, son fianzas de $1,000 para cada uno de esos cargos. Pero después tiene una violación de las condiciones de su régimen probatorio. En eso tiene detención sin posibilidad de tener fianza. Y la corte decide que existe motivo fundado.
¿Decide motivo por acá? Judge, considering he has a no bond hold on his VOP at this time, the defense has nothing to add.
Ya que el señor tiene esa condición de no poder fijar una fianza en el tercer cargo de violación de condiciones del régimen probatorio, no vamos a decir nada de parte de la defensa.
Anything further, State?
Algo del
Your Honor, the
Estado.
state would just ask that the bond remain in place for counts 1 and 2.
De parte del Estado se pide que quede igual la cantidad de fianza que se le fijó para el cargo número 1 y cargo número 2.
All right, leave the 2 bonds in place, and count 3 is no bond. You're going tomorrow before Judge Wood at 9:30 a.m.
Muy bien, entonces queda igual la fianza para el cargo número 1 y el cargo número 2. El tercero es la violación de condiciones de régimen probatorio. Mañana a las 9:30 de la mañana se presenta para ese cargo en frente del juez Wood.
Thank you, sir. Good luck to you.
Gracias, señor, y que tenga buena suerte.
Next one is, what did you say, Jorge Mejia?
Mejia,
What
Your
page?
Honor.
I think the next
Conti.
last case on your docket, he's in contact,
Can you tell the, what page?
page 18.
Do you see that, Madam Interpreter?
I do, Your Honor,
Okay.
thank you.
All right, are you Jorge Mejia?
¿Usted es el señor Jorge Mejía?
Sí.
Yes, yes, Your Honor.
Okay, this says 4, 5, and 6, signed by Judge Duffy, 48 hours to perfect.
I have nothing additional. He can be ROR on these counts, Judge.
Okay, per state,
Lo que vemos
no
son
additional
cargos
information.
4, 5 y 6 y el Estado tenía los 48 horas para presentar más, pero no van a añadir nada, entonces puede quedar en libertad bajo su propia palabra para estos cargos. Y de la
Okay,
defensa,
so counts 4, 5, and 6, He'll be ROR'd.
De la señoría, el cargo 4, 5 y 6 quedan de fianza bajo libertad bajo su propia palabra.
Thank you, sir. Good luck to you.
Muchas gracias.
Okay, thank you very much.
You're
Suerte,
welcome.
señor.
All right, okay.
Judge, did you find probable cause? Oh,
No,
Thank you.
you're welcome. David Meinking,
Have a nice morning.
thank you so much. Have a
Good
great
to
day.
see you, Judge.
We'll see you this afternoon, you too. David Meinking.
He's here present, Judge, at Maine.
Okay, you have a capious misdemeanor for suspended driver's license, first offense. They set a bond of $500. What say you, defense?
Judge, in speaking with Mr. Meinking, he wishes to ask the court if you would consider resolving the matter today.
Sure, I don't know, do we have a driving record on Mr. Meinking, Madam Clerk? Thank you. Okay. This will be his second. I have to tell you, all he has holding him is 1, 2, 3, 4 tickets in Broward. I mean, I don't know what they are, but, and this will be strike 2.
I understand. Let me talk to him 1 second, Judge.
And I don't know why he doesn't take the $293 and get a driver's license. I don't know if he's eligible for something, but.
Judge, in speaking with Mr. Meinking, I did advise him as far as potentially, if he is able to pay off, I believe, the citations which the court was referring to and obtain a valid DL, that may be to his benefit. And that was a good idea, rather than using court costs as far as the $293, to apply it towards those payments. That would help him in the long run as far as obtaining a valid DL. Judge, would Your Honor, and then I looked into as far as why he actually missed court. He basically said he simply forgot. He didn't mean to, he just forgot. He's asking, Judge, he's not going to forget again. He's going to make it a point to actually be in court and take your advice and try and get a valid license. Would Your Honor consider releasing him ROR on this matter so he could do that?
Sure, but here's the thing, I can tell him that he's gonna have to bring in proof to these judges that he paid, that he's trying to pay something.
And that's what I told him.
I'm just telling you. All right, sir, ROR, good luck to you.
Thank you, ma'am.
Michael Cermak?
Mr. Cermak, come on up, please. Good morning, Your Honor.
All right, good morning, sir. You have trespass property, not structure or conveyance. I just want you to know, Mr. Romero, and I don't want your client responding. He was observed sitting on the curtilage of the property between Walgreens and Jan's Homemade Candy on North Ocean Drive, and he was given previous trespass warnings 2 times not to be there. Court finds probable cause. What say you, state? Defense.
Judge, Mr. Cermak wishes to ask the court if you would consider resolving. He understands as far as the location of Walgreens, and he's going to make it a point not to return there again. His words, ever again.
Where does he live?
Sea Ranch Lakes.
Says he's at large. Does he want the receiving center? I don't care, I'm just Doesn't make a difference, and it's not gonna make a difference with what I'm gonna do in this case.
Thank you, John.
Sorry, is there an offer sealed?
From what, I'm sorry.
Your Honor, it's adjudication time served.
From what he advised me, he lives with a friend in Sea Lakes Ranch, so he appreciates the court reaching out to try and extend CRC, but at this time, he says he has a place to stay. And from what he advised me, wishes to accept the state's offer, Judge. And he promises not to return.
Yeah. No,
All right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, Your
All
Honor.
right, Michael Cermak, CERMAK.
Yes, Your Honor.
All right, you understand no return means no return, sir?
Yes.
And I'm ordering it to Walgreens and Jan's Candy.
Okay.
Not even on the sidewalk, the curtilage of the property. Walk on the other side of the street. You're not allowed back there, you understand?
Yes, Your Honor.
All right, because this is the third time. So,
Right.
how do you want to plead? Guilty, not guilty, no contest to trespassing property, not a structure or conveyance?
No contest, Your
And
Honor.
you've had enough of time to talk to your attorney, Mr. Romero?
Yes.
And you're giving up all your rights to a trial?
Yes.
You're doing this freely and voluntarily?
Yes, Your Honor.
Ever been treated for a mental illness?
No.
All right, court's gonna accept your plea, find that's freely and voluntarily entered, court has reviewed the court file, finds probable cause for the plea, adjudication, time served, $293 in court costs, 6 months partial payments, no return to Walgreens or Jan's Candy. You have 30 days to appeal the legality of a sentence to the court. If you can't afford an attorney, one will be appointed. No return, sir.
Yes, Your Honor.
Thank you. LeCedric Brunson, please.
North Broad Medical Reset.
Okay, we'll give it till tomorrow. What page is that? Kimberly Davis.
He's here present, Judge, at Maine. He's approaching, and he declined the services of public defender.
All right, this is an MI case, and I am going to appoint the public defender for purposes of today. Okay, sir, you have a capious misdemeanor for $250. You're going before Judge Wren tomorrow, Division MI, at 9 a.m. Court does find probable cause. Thank you, sir. Good luck to you. Timothy Howell.
Judge, Mr. Howell also declined the services of public defender. Good day, Judge.
Good morning, sir. Sir, you understand if you can't, you can represent yourself, but if you can't afford an attorney, one will be appointed. Do you understand?
Yes, ma'am.
All right. So you want to represent yourself or you want the public defender?
I kind of got,
Don't talk about the facts of your case.
No, I'm not. I'm sorry. I have an attorney, but if I don't want to stop him from doing what he's doing, if I could just resolve one of the cases in or at least the cannabis case, I could get back to court.
All right, so you have to make a decision. Do you want to represent yourself or do you want the public defender for purposes of today? I want to caution you hold on, before you respond, you have the right to remain silent. Anything you say or do can and will be used against you. And that's one of the, weaknesses or issues with you representing yourself. So we're only here today on probable cause. We're only here on your bond and release conditions. So what would you like to do? Do you want us to call up your private attorney? Do you want us to give you more time to get your attorney? We'll continue the hearing. If you want to bind out in the meantime on $100, you can. Or you can represent yourself or have the public defender for purposes of today.
Yes, ma'am. If I represent myself, I'd only ask for release on my own recognizance so I can handle this.
All right, so you want to represent yourself today, sir?
Yes, ma'am.
Okay, so you're charged with possession of cannabis, 20 grams or less, $100 bond. Count 2 is resisting an officer obstructing without violence. Court does find probable cause. Can you pay the $100 bond?
I can't pay it at this time, miss.
Why not? Do you have money in the bank?
I don't have any access to do anything right now.
Where's your money, sir?
I got money at home, not $100.
You have money at home, but not $100?
Yeah, I just paid my phone bill, all kind of stuff.
What do you do for a living?
I'm an auto mechanic. I work on the side a little. I do like little side jobs. I do the labor pool from time to time.
Do you have any other form of income?
I mean, I got a bank account, but nothing's really in it.
Okay.
The court should be aware, Mr. Howell he's got 2 cases right now. One of which he's out on bond for grand theft and 5 counts of credit card forgery, which is concerning considering the allegations here, according to the manager of the restaurant. He was trying to use multiple credit cards in different names to make a payment.
No, objection. In different names.
Okay, here we go. So,
Yes.
sure you don't want the public defender, sir?
Yeah, I'll take the public defender for this time.
Okay, you're gonna have to fill out an application.
Judge, I think I heard the tail end. I don't know if Mr. Lunder said he had some open cases.
Yeah, and then it says, upon arrival, the restaurant manager advised the defendant attempted to use multiple cards under different names to pay.
Judge, objection. I got it. Yeah. Judge, the only thing I'm going to be asking for, Your Honor, is certainly if that's in front of different division, that prosecutor can make an appropriate motion before the judge. This is a cannabis that's here before you. He said he
I'm
can
not
afford
talking
it.
about that, we're talking about the bond though, but he has an open case.
Correct. It's a cannabis from what he's telling me, and I overheard. There's no way he can afford it, so I'm going to ask you an ROR on this nonviolent misdemeanor cannabis offense, Judge.
He was also
He
picked
said
up in
he
April.
promises to come back to court.
He was also picked up in April this year on a capias for failure to appear in court.
I'll put him on standard pretrial. Well, you can pay the $100, sir, hold on, we're not done. Or you can pay the $100 bond, you're the one that has pending cases. You want me to standard pretrial or leave the bond in place?
Standard pretrial, Judge.
All right, I want him calling in 7 days a week.
Yes, Judge.
No bond is required.
Judge, would you consider calling in twice a week and reporting once a month?
Sure.
Okay.
Kelly Mansfield,
Conti, Your Honor.
thank you. All right, hello, Mr. Mansfield, how are you?
Not doing too well.
All right, it says 10-2, second look at 1 p.m. He has Division MJ this morning at 9 a.m. Did he go before his division judge? Does anybody know what's going on here?
I went to one judge yesterday.
And what happened?
She said she would set it for today.
All right, that was probably, was it me?
I'm quite sure. You look like her.
Okay, well, I'm glad I look like me. What are we doing with this case, folks? Does anybody remember? Was this a second look?
No, the issue was, Your Honor, and the reason I couldn't make an offer yesterday is because it appears it's a DWS, but there was a crash. There's potential restitution issues. I thought he was supposed to be seeing Judge Diaz, but...
I set him for a second look at 1 p.m. today. He was supposed to go to Judge Diaz. All right, give us 1 moment, sir. She will, so he was magistrated. So let's reset this for second look Friday, because I don't know what time Judge Diaz is gonna do it. And Friday is
5th.
October 5th at 1 PM. So either tomorrow or Thursday, you're gonna go to Judge Diaz in the morning, okay? And you might want to write the ASA a letter. I'm going to do a second look on Friday, Madam Clerk, at 1 PM. We'll follow up on it, okay? Thank you. All right, good luck, sir. Christopher Falzoni.
He's in court, Judge, for his arraignment this
All
morning.
right, so let's reset for tomorrow. 10-3-1-8. Oh, says he's going before his division judge. Let's see if we can get him here this afternoon then. Who is he? Who's his division judge? Gosh, okay. Because tomorrow he has court, so I don't want to get him in. All right. Stephen Williams, Judge Fine. That is courtroom. Jackie, will it help you? It's NW 4780. 4780. Thank you, Judge Fine. Stephen Williams.
Mr. Williams is here present, Judge, at Maine.
Okay, Mr. Williams, you have ad charges, burglary, unoccupied conveyance, unarmed. We need to talk about bond. Count 2 is petty theft, second degree, first offense. There's no bond required for that. The court does find probable cause. Court's going to order no victim contact with the alleged victim with the initials KRM. And no return, sir, to...
Yes, ma'am.
Is there any no return, State?
No contact with the victim, Your Honor.
Okay, just no contact with the victim. Do you understand?
Yes, ma'am.
All right, the alleged victim is the owner of the car that you allegedly smashed the window of. All right, what say you, State?
Your Honor, he's currently on pretrial GPS on the first Berg dwelling count.
Okay,
That is correct, Judge. He was magistrated a couple days ago. These are ad charges. He hasn't been released. Judge, he lives in Lauderhill with his grandmother. He's right now working at a labor pool. He can't possibly afford a monetary bond. I'd ask you to impose the same conditions, place him on pretrial release with a monitor.
okay, GPS level 2, State?
I believe so, yes, Judge.
All right, so no bond required, no victim contact, GPS level 2. Thank you, sir. Venel Cineas?
Mr. Cineas, come on up, please.
Okay, Mr. Cineas, you have ag assault with a deadly weapon without intent to kill. Court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the name of David DeRosso. Do you understand, sir?
Yes.
Or DeRosa? DEROSA. What say you, State?
Your Honor, the state would ask for $7,500 bond and no victim contact.
Hello, Mr. Odom. Nice to see you. Good. Okay, defense?
Judge, there's no way Mr. Cineas is going to be able to afford the $7,500 bond. We'd be asking the court to consider a $1,000 bond with standard pretrial release. Judge, he's 26 years old, been living in our community now for the past 10 years. He works for a landscaping company in which he gets paid daily, approximately $100 a day when the weather allows him to work. He lives in Cold Springs with his parents. His father is the one supporting the family. He also works for a landscaping company. Judge, he attended Coral Glades High School. Judge, my understanding, he has limited contact with the system. It's been, I believe, over a year. Judge, so that's why we're requesting the court consider releasing him on a $1,000 bond with standard pretrial release.
State, what's his priors?
Your Honor, he has resisting without violence, leaving the scene last year, 2017, Judge.
That's it?
Yes.
All right, $2,500 bond, no victim contact, no possession of any firearms, ammunition, or weapons, sir. Thank you. Mike Arliss.
Mr. Arliss?
Mr. Odom, there's a phone over there you can use. Hold on. License is suspended. Second offense, $100 bond. Count 2 is failure to register a motor vehicle. Count 3, attaching a registration plate not a sign. Counts 4 and 5 are failure to provide proof of liability security not for magistrate. And you do have a capious felony, no bond hold, for a possession of cocaine in front of Judge Porth. You are no-show at a status. Court does find probable cause.
Judge, considering his no bond hold.
$1.
$1. Thank you, Judge.
Thank you. Pedro Cabrera Medina?
He's here present, Judge, at Maine.
Okay, Mr. Medina, you have burglary, occupied conveyance, unarmed. We need to talk about bond. That's counts 1, 3, 4, 7. Count 2 is grand theft auto for a $1,000 bond, and that's also the grand theft autos count 2, 5, 6, 8, and 9. Count 10 is the capious misdemeanor 4. It says operating without a valid license. Court does find probable cause. Oh, that's $250. What say you, State?
Your Honor, the state would ask for $1,000 bond on each count.
Judge, I don't think he stole any cars. In reviewing the probable cause affidavit, it doesn't look like.
There's a bunch of them.
I have 2 reports.
All right, well, you don't have them all.
Oh, well, that happens.
If you look at all my tabs, that's all, look.
Oh, no, I'm definitely missing something. Give me a moment, Judge, if you would.
Sure. Why don't we just pass this and continue? David Sultan.
No problem. Have a seat, sir.
Who's your next? Do you have David Sultan there?
Mr. Sultan is right here, Judge.
Okay, Mr. Sultan, you have fraud, utter a false bank check, draft note, $1,000 bond. Count 2 is petty theft, first degree between $100 to $300, $100 bond. Court does find probable cause.
Judge, this should be quick. He was extradited from Jacksonville. He currently has a hold. My understanding is, I believe he told me he has a court date tomorrow, October 3rd, so at this time, we are not asking for anything on these 2 pending matters.
Okay, I'm gonna leave the $1,000 bond in place. I am gonna do $1 on the petty theft. Thank you.
Okay.
Christopher Mantel?
Mr. Mantell, come on up, please.
Okay, Mr. Mantel, you have grand theft between $300 and $5,000, $1,000 bond. This is the co-defendant of the one where they took the money allegedly from going through TSA checkpoint. What say you, Mr. Romero?
Judge, correct me if I'm wrong. I know the other co-defendant, I believe, was in a different facility. I believe the court imposed a pretrial release. That's what we're going to be asking for Mr. Mantell, standard pretrial release. Right now, he is homeless, from what he informed me. However, he did tell me he has a mailing address. It's of his friend in Lake Worth that he communicates with. He's 31 years old. At this time, unfortunately, not working, he's currently looking for work, so there's no way he can afford any sort of monetary bond. So that's why we're gonna be requesting standard pretrial release on Mr. Mantel's behalf.
Is,
All right, just let me verify, is your what's this 2603 Lake Avenue, Lake Worth?
It's the same as Misty Elsner's. We're in treatment there. That's where we're in treatment.
What's the name of the place?
Life Recovery Center.
Yeah, you can come in. Hang out. Okay, what's his prior state?
2016 felony. These are all out of Ohio as well. 2016 felony receiving stolen property. 2016 theft, harassing phone threats or abuse. 2012, uttering a forged instrument, felony possession of drugs, theft. 2011, theft 2011, uttering a forged instrument 2011, disorderly intoxication 2006. So clearly has a more serious criminal history than his co-defendant.
2 years clean, Judge.
All right, I'm gonna require that his address be verified at Life Recovery. I'll put him on standard pretrial, won't require a bond. No victim contact, direct or indirect with AD. He's required to live at Life Recovery Center. Where's that located, sir? Do you know the number or do you know the town?
It's Lake Worth.
All right, and they're gonna tell me you can come back there and live, right?
Yes, ma'am.
Okay, if they don't, it has to be verified before you leave.
I'm piggybacking off of Misty Elsner. That's where we were staying prior to this incident.
All right, Mr. Romero, I sense that there's gonna be an issue. He's gotta live there. So they're gonna have to call and verify. Unless he wants to go to another place.
Judge, he doesn't know if he can reside there. That's the truth. He doesn't know.
All right, well, he shouldn't have said that when I asked him. So where is he gonna live? That's my concern.
Judge, right now, from what he informed me, like I said earlier, he's homeless.
I apologize, Your Honor.
All right, where does he wanna live? He has to live at a place. I don't care where it is, but I'm not just letting him out on the street. He has too much of a prior history. He's going to the airport, stealing people's money. Allegedly.
He's gonna try and find a local shelter here in Broward County, Judge.
All right, State, what's your position?
Your Honor, we would ask that the bond remain in place.
All right, either $1,000 bond or he verifies an address where he can live. Thank you, sir. Good luck to you. Abigail Rowe, where did I get this?
No, I just need was it probable cause or not?
It was already found on 10-1.
Thank you.
It says defendant is to be brought back to court for bond conditions.
Okay, thank you, Judge.
You're welcome. You're welcome. All right, Brian Lamandeline.
Mr. Lamandeline, one up.
Okay, Mr. Lamandeline, you have grand theft between $300 and $5,000, $1,000 bond. You do have a probation violation. Is this in 94806? Yes, okay. So no return, sir, to the Home Depot. located at 1151 West Copans Road. What say you, defense? $1,000 bond.
My understanding, he has a no bond hold here in Broward County, so therefore at this I have nothing to add on count one.
Thank you, sir. Good luck to you. Craig Bouvel Frazier.
Mr. Frazier, come on up, please.
Mr. Sinat?
Okay, sir, you have fleeing with disregard to safety of persons or property. We need to talk about bond. You also have aggravated assault on an officer, firefighter, EMT. Court does find probable cause. This is a capias not in custody. What say you, state?
Your Honor, the state would ask for 25,000 per count in 2000 and GPS monitor in 2015 in Indiana. He did do 5 years in prison for financial institution fraud.
And Your Honor, also, out of Leon County in 2009, he was sentenced to 18-month state prison for the following offenses. It looks like 14 counts of uttering a forged instrument, 3 counts of fraudulent use of personal identification information, 5 counts of grand theft, 6 burglaries of a structure, he was released from state prison September 8th, 2015, and then went to state prison in Indiana on September 25th.
Is this the one where he was allegedly going 120 miles an hour
Yes, Your Honor.
in a Porsche Macan?
He also, in 2012, in the state of Georgia, was sentenced to 3 years in state prison for identity theft.
Does he have any prior violent offenses?
I don't see any, Your Honor. Our concern is, one, he's been arrested for failures to appear in Florida and Georgia. Considering his criminal
Well,
history.
we can do a GPS with that. And I'm not saying,
I understand, Your Honor, but I think, considering the potential consequences he faces based on his criminal history, Your Honor, I think is significant, and the lengths he went to avoid apprehension in this case, I think a significant bond is needed in addition to just having a GPS monitor on his ankle.
all right, ma'am, you just walked in. Can you state your first and last name?
My name Mary Parrish.
Parrish?
Right.
Okay, and your relationship to Mr. Frazier?
That's my son.
Okay. All right, so we just were recapping, and I'll give you an opportunity to say something. Your son is charged with fleeing, disregard of safety to persons or property. We need to talk about bond. An aggravated assault on an officer, firefighter, EMT, we're talking about bond. They just went through your son's prior criminal history, which is quite lengthy. And what else, state? I'm sorry to interrupt.
Yeah.
All right, defense?
Judge, one moment, please.
I have a history of other stuff, but they got the wrong person.
All right, ma'am, if you could just withhold your comments till we're finished, okay? Thank you so much.
Judge, as you can see, this is a not in custody capias. Mr. Frazier doesn't know anything about this. When was the date of incident on this alleged offense, Judge? Thank you for that. Judge, he's looking forward to his day in court. He's 33 years old. As you could see, Judge, he has priors, but he was released from prison in January 2017. So he's been clean since then, Judge. Right now, he's kind of self-employed. He does home improvement. He makes approximately $350 per week doing that. He lives in Lauderhill with his mother, and she appreciates the family support. My understanding, Judge, is his mother is a stay-at-home mom or wife. His stepfather works at Publix, so he's going to be reaching out to friends and family to help post that monetary bond. But from what the state has suggested, a $50,000 bond is going to be out of his reach. We'd be asking the court to consider placing Mr. Frazier as far as on monetary bond of $2,000 on count 1 and $2,000 on count 2, Judge.
And, Your Honor, I have a bit of a concern about Mr. Romero's representation about Mr. Frazier's financial means. In this case, he's alleged to be driving a Porsche. I can tell you, in July 23rd of 2017, according to DHSMV, Mr. Frazier purchased a 2014 BMW.
Judge, Mr. Frazier doesn't own a Porsche. I believe that's what this is alleging.
He does own a 2014 BMW.
I think the police report's pretty clear that the Porsche did not belong to the person who was driving it.
I understand he doesn't own the Porsche, but according to the state, he owns a 2014 BMW in his name.
Judge, my understanding, he didn't buy the vehicle when he was, I believe. Judge, my understanding, Judge, is that when he was, I believe, as a present from his stepfather, that was purchased for him. In which I don't know what sort of arrangement stepfather has regarding that Porsche as far as monthly payments, but that was a gift for Mr. Frazier. Mr. Frazier did not purchase the vehicle.
All right, ma'am, would you like to tell the court something? If you could speak into the microphone.
I'm sorry.
Take your time.
I know them, and right, the little court thing we having right now, they don't have time to go through that, and that's not what they're here for. But it's just like common sense. You can look through the paperwork and you know you got the wrong person. Everything when they came to my house, everything, the car's not registered to him. That's not him. They come like 2 months later. Everything they said, nothing is true. They came there, they didn't read him his rights. They came there, we're looking for Craig Frazier. You never asked about the car he was in. They never even asked who's the owner of the car, where the tag. And it was all crazy. That car, Craig don't own nothing. Craig been going to church every Sunday. You understand what I'm saying? And he been going to work with my dad, them no problem at all. I call myself trying to help him because he doing all the right things. You understand what I'm saying? And my husband, we refinanced. This my husband. We refinanced our house and we got.
You could talk into the
We
microphone.
refinanced our house and we got him some transportation to get back and forth to work in. Yeah, so but that Porsche and all the other stuff don't belong to him. That's all we got is that house and that car he in, and we can show proof of how we got it. So yes, he had priors, but that has nothing to do with this. They came to the house asking for him. They never even asked who the owner of the Porsche. They never even asked about the tag number or nothing. They just, we looking for a Craig Frazier, a boy with a mouth full of golds, and my son don't even have one gold in his mouth. Then they had all them guns. They didn't even read them his rights or nothing like this. It just was crazy. You understand what I'm saying? I never seen nothing like that. But he been doing good. So yeah, we trying to help him because he trying to do the right thing. As long as he doing the right thing, I don't mind about trying to help him. We don't have that kind of no money because we get a BMW 2014. Yeah, we don't have no lot of money to be putting down on to try to get him out. But I do want him home with me, until we can get to court and let them see that all this is a mistake. I think they even know it a mistake. You know what? My son told me on his way going to the
Let's not
jailhouse.
get into the facts of the case, ma'am.
Okay, I'm sorry. All right, but anyway, that's it. I'm praying and I ask in Jesus, please, Lord, let him come home with me.
Judge, it
And
doesn't
I don't have
seem
no
clear from the
money.
report as to how Mr. Frazier was tied into this incident. I know the officer says he had an unobstructed view of the driver.
I was just looking at that with the
But he says he
distinguished
has-
marks on his face.
Yeah, but he doesn't describe those marks. He doesn't say what the tattoos were or what they looked like. And if what his mother says is true, that they were looking for someone with gold teeth, Mr. Frazier does not have any gold teeth.
Well, I don't see that in the probable cause affidavit.
It's not in the probable cause
But it
affidavit.
says he has tattoos on his forehead and neck. And from looking from here, unless Craig wants to do me a close shot, I can't tell whether he has tattoos on his forehead. We'll call up Craig.
Hello, you have reached the office of video operator.
Judge, even if he does have tattoos, he's not the only person with facial tattoos. No, that's not all that uncommon. And
Hi, Pat. It's Judge Malika. Can you do me a favor? Is there any way you could get me a real close-up of the defendant in this? It says that, in a PC that he has, tattoos on his face and I can't see it, on his forehead and neck, just for a moment.
Do you have access to BSO pics on your computer?
Well,
You can look at his booking photo, it's very clear.
Yo. Yes. Yep. I hear you.
You check that out. And he does, Your Honor.
all right, thank you very much.
Well, we've established that Mr. Frazier is one of many individuals with facial tattoos. I also find it somewhat concerning, Your Honor, that during this high-speed chase, this officer is able to get a good enough look at Mr. Frazier to say that he has specific types of tattoos, but he never mentions what those tattoos are. And I just find it somewhat incredulous that that could happen during a high-speed chase like this.
Your Honor, I would also note, it is noted in the report that the officer looked at his David photograph and ID'd him based on that.
Well, misidentification is the leading cause of innocent people being convicted of crimes. And also, I would note that the probable cause affidavit, the victim or owner of the Porsche was extremely uncooperative with the investigation that was being conducted. In fact, as the report says, he became irate and uncooperative.
And once again, Mr. Reed doesn't read the whole sentence, where he said he had no knowledge of where Craig nor the Porsche was, implying that Craig had the Porsche, Your Honor.
I don't think that's an implication at all.
And again, Mr. Reedy is making a speculative argument on no basis. Now, certainly the public defender's office, if they represent Mr. Frazier, can depose the arresting officer and question him as to his identification, but he has no basis at this point in time. There's a misidentification. He made the argument about the facial tattoos. It turns out there are, and when that matches up, he jumps to the next argument.
I never said there weren't. We always knew that he had facial tattoos. It's very obvious that he does. What's not obvious is how an officer can identify an individual during a high-speed chase. I think it's very
Court did
questionable.
find probable cause, and I'm gonna keep my ruling. I appreciate your argument, but court does find probable cause. A lot of these arguments are for later on down the road. I understand and appreciate your arguments, and they might very well pan out in Mr. Frazier's favor. But for right now, let's just address the bond. Was there anything else you'd like to state, ma'am?
I don't have no lot of money to bond him out.
I'm sorry,
I
ma'am.
did one is I don't have no lot of money to bond him out right now. All we have is what my husband, he's the only one working, My husband is working at Publix. Like I said, we was able to get the car because I could show proof of we refinanced our house to get a car. You understand? To get that car. Uh, he going as fast as y'all claim he was going. I never see nobody 1 or 2 o'clock and whatever time y'all claim it was, how you could see tattoos on the face and stuff like that. I never seen nothing like that. This is, I never, I never seen that before. How could somebody be on a high speed chase and see tattoos in somebody's face that time of 2 o'clock in the morning and it's dark out the door? Ooh, I'm sorry about that.
That's all right, no problem. Don't worry about it.
I never seen that. It's like they looking for something. They just trying to put them in the system.
All right, GPS level 2. Court's gonna do $10,000 bond on 1, $5,000 bond on 2. Does your client work? Because I'm gonna do a curfew.
Judge, he does home improvement, and he,
All right, I'm doing 7 p.m. to 6 a.m. Thank you, ma'am. Good luck to you. Thank you, sir. D'Angelo Brim. And then we're gonna do Mr. Odom first. No,
Judge, I'm sorry, who did you call?
D'Angelo Marquis.
Oh, Brim, he bonded.
All right, then let's do Mr. Odom. Step up.
Yes, Judge.
We're taking a break for whoever doesn't have to be here for the MOs. Well, hold on, let me just make sure. Mr. Reedy, let me just make sure none of these.
Walking up the hall, Judge, I'll be gone 2 minutes.
All
Chantel
right.
Dub does have a state misdemeanor case attached to,
All right, let's start with Chantel Dube.
She's here present, Judge, at Maine.
All right,
good morning.
we have
Excuse me.
Mr. Romero here, so.
Great, he'll do an awesome
And
job.
it field tested positive, 1 gram.
Judge, here's what,
All right, so let me tell her what she's charged with. Ms. Dube, you have possession of cannabis, 20 grams or less, $100 bond. You do have a capious misdemeanor, Division MH, who is
Judge Poole.
Judge Pohl. Thank you very much.
No worries, Judge.
For possession of drug paraphernalia, $250 bond. Would he like to resolve it, or would she like to resolve her cases today?
Judge, in speaking with Ms. Dube earlier today, she advised me she does. She wishes to resolve the matter.
Okay, State, you have an offer?
It'd be a withhold on count 1.
Withhold and court costs on each one.
She wishes to accept the.
Raise your right
state's
hand. Do you
offer.
swear and or affirm to tell the truth?
Yes.
All right, put your hand down. Is your name Chantel Dube, D-U-B-E?
Yes.
All right, Ms. Dube, it's my understanding you want to resolve your cases today through your attorney, Mr. Romero, and through your attorney, Mr. Odom, who's actually standing in for Mr. McLawrence. Is that correct, ma'am?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any drugs, alcohol, or medication?
No.
Ever been treated for a mental illness?
No.
All right, how do you want to plead? Guilty, not guilty, no contest to possession of cannabis, 20 grams or less, and to possession of drug paraphernalia.
No contest.
Do you feel that no contest is in your best interest for both charges?
Yes.
All right, court's going to accept your plea. Find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Withhold of adjudication and court costs on count 1, it's $308. On count 2, the MO case, court costs are $78. 6 months to pay on each. Partial payments accepted. The court takes judicial notice of the time served in the Broward County Jail. You have 30 days to appeal the legality of a sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, ma'am. Good luck to you. Next one is Denise Griesler. Denise Griesler, please.
North Broward, she refused, Your Honor.
Okay, she refused. Court's gonna ROR her. Thank you, good luck. Oh, let me put that she refused, I'm sorry. Defendant refused and voluntarily absented herself from court. Normally I wouldn't appoint you, but for Mr. Odom, normally because they didn't say they wanted a person, I don't know, did you speak to them?
Well, Judge, we've represented her in the past, and she's the one that you recall, she's got like a few cases that are.
No, I know, but in any event, I like for them to at least appear before me, but for purposes of today, I will appoint you, otherwise, you're gonna have to do your appointment up in the division if I do that next time, okay? Thank you. So I signed it now. You're having me sign it for 2 cases?
Well, she also has another one in Judge Carpenter's toy.
All right, which one is that?
18877C MOJ.
All right, you're gonna have to have Judge Carpenter Toy do that, because it's not in front of me.
Just trying to expedite this.
No, I understand, but it's just not appropriate for me to do it in Judge Toy's division when it's pending there. Okay. Any other cases?
No, that's all I have.
All right, thank you. All right, Mr. Shate, who do you have?
Judge, I have Matthew Bartlett on page 16. Judge,
Okay.
he's also being held on a violation of probation for a felony matter.
All right,
So,
let's get him up. Where is he?
He's in Maine.
Oh, hold on one moment. Thank you.
He's approaching, Judge, he's here at me.
Okay. All right, Mr. Bartlett, good morning, sir. You have probation violation, no bond hold. You also have a municipal ordinance violation. You are going before your division judge, Judge Elizabeth Shear, tomorrow at 8:45 a.m. Municipal ordinance violation, $25 bond for trespass. Court will ROR or $1?
$1, Judge. That way he gets
Court
some
will set
credit for
bond
this.
of $1 on the municipal ordinance violation, and you'll see Judge Shear tomorrow. I appoint Steve Shate. Thank you, sir. Good luck to you.
Thank you, Judge. That's all I have.
Because I have to speak to the, I can't, I have no bond on the, probation violation, correct?
Correct. You'll see Judge Shear tomorrow.
All right, great, thank you.
Thank you. And I said a $1 bond on the trespass, no return. Anthony, is that it?
That's it, Judge.
Thank
very
you.
much. Take care.
Anthony Allen?
Judge, he's here present.
Okay, Mr. Allen, you have commit a first-degree felony with a weapon, and you have trafficking cocaine over 400 grams, less than 150 grams. It's 100 and, no bond holds for each one. Court does find probable cause. What say you, State?
Judge, I have a probable cause argument.
Sure.
With regard to the armed aspect of both Mr. Allen and Mr. Sievert's cases,
Okay, you want to call Sievert at the same time? Should we call both of them?
the argument applies to both.
All right, let's get Mr. Sievert up if he's at main jail. Okay, Mr. Sievert, you have also, did you hear me read Mr. Allen's charges?
Yes, ma'am.
All right, you have the same charges, so go ahead.
Judge, here's my concern as far as probable cause is concerned. The firearm is located in the vehicle underneath the rear passenger seat. I would argue that that is not the using a weapon in the commission of a felony. We don't know who might have had access to the weapon. We don't know whose weapon it is. It does not appear to be in any way involved in the transaction that allegedly occurred between these gentlemen and the undercover officer. So I do not believe that there is grounds to support a probable cause for count 1 or probable cause for the armed aspect of count 2.
Says after the exchange, defendant Allen put the kilos in the rear of a Chevy vehicle on top of the child's car seat.
But it doesn't say that the firearm was in any way involved in the commission of this offense. It was merely in the vehicle under the passenger seat, and we don't know which side of the car the baby seat was on.
But isn't this really an argument, respectfully, Mr. Reedy, for later on down the road?
The court can look at it 2 ways. I think the court can look at it as a probable cause argument, and the court can also take it into consideration in the determinations of the cause. Because I do believe that that is a
have, the state concedes no PC on count one, it wasn't used or displayed.
Okay, so no PC on count one,
Yes. Count
no
two.
PC per state and defense, go ahead.
Count two, there's clearly constructive possession of the firearm for both co-defendants, Your Honor. And for armed trafficking, the firearm doesn't need to be used, it doesn't need to be displayed. There just has to be possession, whether actual or constructive, during the commission of the trafficking. And there was certainly, it certainly was in constructive possession during the trafficking, as you stated, when the drugs were put into the car. And it was certainly within reach of both co-defendants.
I think there's going to be a defense of whether or not there is constructive possession of this firearm as a central aspect of this case. Certainly, the court can take that into consideration when determining what bond is appropriate.
And, Your Honor, on count two, for each co-defendant, the state is going to be seeking a no bond hold. These armed trafficking is a punishable by life offense. Your Honor, I would note the allegations in the report.
All right, so the court is gonna find probable cause on count two for Mr. Randy Sievert and for Anthony Allen. However, per the state and defense, on count one, there's no PC for Mr. Randy Sievert and Mr. Anthony Allen. Go ahead.
Your Honor, just relying upon the allegations, it would appear both were participants in this drug deal for multiple kilograms of cocaine from an undercover detective. The firearm was located under the front passenger seat. The detective Hansman notes, and why it's so concerning and why it is such a serious felony, is that the Detective Hansman notes in his training and experience as a law enforcement officer why drug dealers will keep firearms. And certainly this could have potentially put any of law enforcement involved in this case's safety at risk, Your Honor. I would note this involved a significant amount of money. It does appear neither co-defendant resides in Broward. They came to Broward to conduct this transaction. So we would be requesting a no bond hold on each at this time, for first appearance purposes only.
And on behalf of Mr. Allen and Mr. Sievert, I'm not going to rehash the arguments I just made about probable cause, but I think it's very important that the court understands that this firearm was not under the front passenger seat. It was underneath the rear passenger seat of the vehicle, even further removed from the actual transaction itself. So again, I would reincorporate the arguments that I just made on these gentlemen's behalf regarding probable cause, and it certainly applies to proof evident presumption great, which is the highest standard we have in criminal law. There is no proof evident presumption great established in this case, again, because of this very specious argument about constructive possession. Just because the officer says they were in constructive possession of it doesn't mean that they were. It's under the rear passenger seat. Also, the court can, in its discretion, if the court does find over defense objection that proof evident presumption grade has been established, this court can, in its discretion, set bond for Mr. Allen and Mr. Sievert, and I would ask the court to set bond for these gentlemen.
Your Honor, I would note one, Mr. Allen was putting the drugs into the back, so certainly it was within his reach. I would note Randy Sievert's listed as 6'2". I think it is reasonable that someone that's 6'2" in the driver's seat, it is within their arm's reach to get a gun, even under a passenger seat.
I don't know about that.
All right, folks, Mr. Allen and Mr. Sievert, I've reviewed the probable cause affidavits filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, both of you are going to be held without bond pending further order of the court. This order is without prejudice for you to file a motion to set bond with the assigned division judge and request a hearing on State v. Arthur. So on count two, there's going to be a no bond hold. Thank you. Good luck to you.
Judge, our only request is in reference to Mr. Allen. We'd be asking Your Honor to enter an order allowing us to photograph the injuries Mr. Allen sustained.
Sure, no problem. Glad to do it. Thank you. Anthony Sinante. Mr. Sinante, you have grand theft between $300 and $5,000. $1,000 bond. Count 2 is possess an anti-shoplifting control device countermeasure, $1,000 bond. Court does find probable cause. Court's gonna order no return, sir.
Judge, I would make the same argument I made on his co-defendant, Ms. Shiro, as to count 2, that there is no anti-shoplifting device involved in
Okay,
this
state
case.
you agree, per
State has
state,
no objection, Judge.
per state and defense. So probable cause is found on count 1 only. No probable cause for count 2. All right, so count 2 is ROR. Count 1, what say you?
The defendant is currently being supervised.
Pretrial services, Your Honor, for 2 separate cases. The first case, 180111073 CF10A. He has 1 count for grand theft greater than 300, less than 5,000. Counts 2 and 3 are retail theft over 300 at multiple locations. And the second case is 180112991 CF10A. For count 4, he was placed on pretrial services for grand theft. And we're asking, since the court found probable cause in this case, that pretrial be revoked for those cases.
Okay, what say you, Mr. Romero?
Judge, unfortunately, he's not gonna be able to afford the monetary bond that's before you, $1,000 right now. He's homeless. He's looking for work. He does have a mailing address that he has. That would be of his mother, who resides in Royal Palm. He's 33 years old, Judge. I'd ask you to take that into consideration, determine reasonable release conditions.
And Your Honor, I did confirm the case that he's out on pretrial. He was arrested with Stephanie Shiro as well.
Okay, no contact with the co-defendant. No return to Coles. Located 9001 West Atlantic Boulevard. Court will set the bond at $500 on the grand theft. The current one, count 2 is ROR, no PC. Case number 1811291 CF10A. Court's gonna do $1,000 bond on the grand theft. And then case 1811073 CF10A. Count 1, the court will do $1,000 bond. Counts 2 and 3, $500 bond each. No contact with the co-defendant. Thank you. Matthew Irvin.
Sir Matthew Irvin? Yes.
Okay, Mr. Irvin, you have a grand theft auto. That $5,000 bond. Court does find probable cause. Well, actually, there was an affidavit to arrest.
Judge, he declined the service of the public defender. I don't.
I can't hear a word he's saying.
She's on the charge of the case or whatnot.
All right, sir, you have the right to remain silent. Anything you say can and will be used against you. Today, we're just here on probable cause, and we're just here to determine what your release conditions and if I should set some bond. If you want, sir, let me finish.
I never was arrested,
Sir?
arrested or nothing on this case.
Sir, I'm asking you to let me finish, okay?
Okay.
You have the right to an attorney. If you want, for purposes of today, you'll have to fill out an application, but I will appoint the public defender. Please do not talk about the facts of your case. Everything's being recorded. You want to represent yourself? Hold on, sir. We're not up to that yet. The question I'm asking you is, do you want to represent yourself or do you want an attorney?
Well, I mean, I need to know what the case is, what you talking about first.
I told you it's for a grand theft auto, $5,000 bond. They're saying on or about September 2nd at 2 p.m. And then it goes on from there. So would you like the attorney? Do you want to, sir, we're not talking about.
This may, I'm saying, because I've been victimized of identity theft. Could this be someone using my name? I'm over here in New Carroll County, and they sent me back over here saying something came up, and then they're not giving me any information on the case or anything. I don't know what you're talking about.
Sir, we're back to the question before I answer you. Do you want to be represented by the public defender, or do you want to represent yourself?
would you give me a side appointed counsel if I need
Do you want
if
me to
I
appoint the
decide to
public?
represent myself?
No, do you want to do you want the public defender to represent you for purposes of today?
Well, can I speak with him for a minute?
Sure, if he'll
Is this
speak to
the
you.
Okay, yeah, man.
Turn off the mic. All right, do we have anybody at North Broward? Anybody left at North Broward? I'm sorry, you turned it off.
McPhee.
All right. Okay, Mr. McPhee, come on up.
Judge, Mr. McPhee has private counsel, Mr. A.J. Amoroso. I understand he's on his way.
Okay, do you know how long he's been on his way?
I called before we started the docket.
What's the number?
It's 954-745-7461.
Yes, Mr. Amoroso, please. This is Judge Malika calling from First Appearance Court.
Oh, he's not in the office. He's in court this morning.
All right, do you have a cell number?
Yes.
Okay. Okay. Okay, thank you. You might want to text him and tell him we're looking for him in Magistrate Court, courtroom 4155, for his client McPhee, okay? Thank you.
Hi, this is AJ.
Hi, AJ Amoroso. This is Judge Malika. How are you?
I'm good, Judge. What's up?
You're on speakerphone. You're being recorded. You're in First Appearance Magistrate Court.
Okay.
I have a gentleman, Alan Chisan McPhee. Are you going to appear for him today?
You have them now, or are you doing it at 1:30?
I'm doing it. I have him right now. So if you'd like to do it over the phone.
Judge, can you give me 15 minutes to get there?
Sure.
I'll be there soon.
Because we're almost done, okay? Thank you. Okay, we'll recall. Let's recall. Okay, Deputy at North Broward, we'll be back in 1 moment, okay? His attorney's on the way.
Okay.
Okay, let's call Matthew Irvin back.
Judge, we're ready.
Okay. All right, Mr. Irvin, come on back up. You have a count of grand theft auto, $5,000 bond. There's a warrant to arrest. The court does find probable cause.
Judge,
What
my
say you?
understanding, Mr. Irvin, he's looking forward to disputing these allegations. He doesn't know anything about it. He's been in custody in Georgia. He was extradited down here. He doesn't know when this took place. No one told him any information about it. He's saying he never had anything to do with any sort of grand theft auto down here in Broward County. But now that he's down here in Georgia, he's going to be residing locally, I believe, in Pompano Beach. From what he had told me, right now he doesn't really have any sort of monetary funds, no money in the bank, nothing to post his bond, which is currently set at $5,000. He's asking Your Honor if you would consider releasing on pretrial release so that he could fight it from the outside and basically prove his innocence, Judge.
Okay, the vehicle was found in Georgia in the same area as where the defendant allegedly lived. I'm going to leave the bond at $5,000. Thank you, sir. Good luck to you. Christina Sterling.
Oh, Your Honor, I'm sorry. In abundance of caution, I just request no victim contact.
And no victim contact, sir. Christina Sterling. Christina Sterling. Or Christian. Good afternoon, Mr. Sterling. You have petty theft, second degree, first offense, no bond required. Count 2 is unlawful possession of personal ID of another for or less $100 bond. You do have a probation violation out of Palm Beach County. Court's gonna set your bond at $1 on count 2. Thank you, sir. Good luck to you.
Judge, would you consider an R warrant count 2 so the probation holds out of West Palm Beach so West Palm can come and pick him up?
Just keep up so he doesn't get a capias. Thank you, sir. Hernando Torres Parado. Bonded? Thank you. Nathan Clifford.
He's coming up, Judge. Yes, ma'am. Yes, Your Honor.
Okay, Mr. Clifford, you have burglary, unoccupied dwelling, unarmed. We need to talk about bond. Count 2 is grand theft between $300 and $5,000. Court does find probable cause. Court's going to order no return to the La Vie Lebanese restaurant located at 281 Southwest 26th Avenue in the city of Pompano Beach, Florida. Do you understand, sir? If you go back there, you will be arrested. What say you, state?
Your Honor, the state's asking for $10,000 on count 1 and count 2 to remain in place, the bond.
I'm sorry, say those amounts again?
On count 1, Your Honor, $10,000. On count 2, $1,000.
Okay, defense?
Judge, my understanding is, I believe you said no return to a business, and this is saying a dwelling, so should this be burglary of a structure?
Defense, state?
So therefore, Judge, on the third-degree felony, Judge, my understanding, Mr. Clifford, and he does have priors from what he said, this is his first, he has no prior felony convictions, he's 44 years old. He's right now, unfortunately, he's homeless, he lives at a local shelter in Blunt Road. He's looking for work, he's financially indigent. We'd be asking you to consider releasing him on pretrial release.
And, Your Honor, the state would object. He had a theft in Broward just in April of this year. He's got a warrant out of the state of Kentucky right now for failing to appear in court.
Didn't I let him out on something? No?
No, you had I believe there were co-defendants in this case, is the allegation.
Judge, from what he said, I mean, he's never been in Kentucky, and that theft was a petty theft. So this is, like I said, I believe his first felony offense.
All right, so let's just get one thing straight. Is this a burglary of an unoccupied structure, unarmed?
Yes.
Unoccupied, correct?
Third-degree felony.
And it would seem the evidence against Mr. Clifford is the undetailed statement of his alleged co-defendant. The officer says he admitted to being at the business. Mr. Clifford said he never went inside the business. And he says, the officer says that the co-defendants, plural, stated Clifford was involved in the burglary. But it doesn't say what they said happened. I think that's extremely vague for probable cause and is not probable cause.
Again, it is probable cause. He admitted he was at the location, and his co-defendants acknowledged he was involved in the burglary, Your Honor. It certainly gives the officer probable cause.
But what did? No, I'm sorry. Go ahead.
He isn't probable cause to believe he was involved in the offense. Mr. Reedy is raising the standard of where probable cause is.
It says the defendant intentionally took multiple liquor bottles.
That doesn't prove anything. That's a conclusatory statement. What's not in this probable cause affidavit is what these co-defendants say Mr. Clifford did to be involved in the burglary that he says he did not commit.
The officer can rely upon his co-defendants.
Okay, court found probable cause for burglary, unoccupied structure, unarmed, count 1, and grand theft between $300 and $5,000 on count 2. What say you, state? Still want a $10,000, $1,000?
No, Your Honor, we're not going to ask for $10,000 in lieu of the fact that it's a burglary.
Okay, so what are you asking for, state?
We'll be asking for $3,500 on one.
Okay, what say you?
Judge, nothing This is his first felony offense. We're going to be requesting pretrial release on Mr. Clifford's behalf. Not asking for mitigating purposes, taking into account what Mr. Reedy said as far as the weakness of the state's case.
It's not his first felony arrest. He was arrested in '01 for aggravated assault, domestic violence out of the state of Kentucky. He's got priors out of Missouri, Indiana, Alabama, and as I previously stated, a current bench warrant for failure to appear in court.
He has a warrant, so I'll do, no bond required, but I'm gonna do a GPS level 2. Thank you, sir, no return. Jahil Claveris.
Your Honor, Mr. Bellis is standing by to appear by phone on Mr.
Sure.
Claveris. He's in North Broward.
What's Mr. Bellis's first name?
Richard.
Just let you know, I don't know if you saw it already. The state provided the paperwork in the case if you wanted to look over it.
Okay, what's Mr. Bellis's phone number, please?
954
Mm-hmm.
472 8305.
All right, this is the one where they charge him with the felony battery.
He was arrested.
$150,000 bond by Judge Cohen. Now it's a change of charge to aggravated battery. So let me get Mr. Bellis on the phone.
Hello?
Mr. Bellis, it's Judge Malika from First Appearance Magistrate Court. How are you, sir?
Good morning. How about yourself?
I'm fine, thank you. We have your client, Mr. Jahil Clervius. Is that your name, sir?
Yes, ma'am.
All right,
Yes,
you wanted
yes,
to
ma'am.
appear by phone, sir? Or would you like to appear in person?
By phone, I wasn't dressed for court, and I thought we had addressed that when he appeared before my client, Judge Bober, about 2 weeks ago, because he's got a violation of probation that he's being held on. The judge said that he would arraign him on that date rather than the first, but apparently that wasn't done, and they didn't address the issue of the change of charge capias.
All right, so I'm just offering you the opportunity. I'm not saying you have to come in person. I just wanted to offer you the opportunity to appear by phone or in person. So I guess we'll
If I
appear.
could- I'm sorry.
No, go ahead.
If I could do it by phone, it would be appreciated.
No problem at all. So, Mr. Clervius, you actually have a change of charge from a felony battery dating violence to aggravated battery, cause disability, bodily harm or disability. We need to talk about bond. I know on the felony battery, I'm looking at the magistrate from Judge Cohen on August 15th. Judge Cohen said $150,000 bond, and he ordered no victim contact. So what say you, State? What are you requesting on this count?
Your Honor, I'm going to ask that the court keep the bond at $150,000. We've actually upfiled the charge. Mr. Clervius is now facing an aggravated battery, which is a second-degree felony rather than a third-degree felony. I've also provided the court with the original probable cause affidavit. And just the level of brutality alleged in this case, I believe the bond is warranted, alleging that he climbed on top of the victim, punching her in the face several times, described by knocking her unconscious, described by witnesses that blood was flying all over the living room. The witness advised that they had to stop Mr. Clervius from attacking the victim, and her injuries, where she had to go to Broward General she had to actually get transferred from University of Broward because she had to be placed in the trauma unit. She suffered a brain bleed, fractured eye socket, numerous blood clots in her nose and throat, lacerated lip which required stitches. Both eyes were severely bruised and her right eye was swollen shut.
Okay, Mr. Bellis?
Yeah, naturally, Mr. Clervius, don't discuss anything. I told Judge Bober and the state when I appeared before Judge Bober previously, the alleged victim came into my office. She doesn't want to see anything bad happen to him. The case had been filed already, so she didn't execute a waiver. So I would ask, that bond is excessive. He has no bond for the violation. He's ineligible for a bond until that case is resolve the violation. I just ask if you'd set a bond in the neighborhood of $20,000. I think $150,000 is excessive, and he does have meritorious defenses to the case.
And Your Honor, I only mention this because what the victim wants to see happen was brought up. It does mention in the detective's sworn report that the victim told her that she is afraid that Jehiel Clairvius will kill her.
All right, so $150,000 bond without prejudice, no victim contact, direct or indirect, with the alleged victim in this case, with the initials TH. And I also am gonna do a GPS level 2 and maintain 1 mile at all times. Thank you, sir, good luck to you. This is without prejudice for you to go. He has the no bond hold before his division judge.
All right, thank you, Judge. All
Thank
the best.
you.
Be well.
Thank
Appreciate you.
Have a good day.
Bye-bye.
No problem, anytime. Bye-bye.
Bye-bye.
Okay, John Bradley. Why are we here on this 48 hours to
Your Honor,
perfect?
I'll wait till they bring him up.
Yeah,
He's here, me.
okay.
Your Honor, all I can tell you, I wasn't here over the weekend, but I was advised that the judge found no PC because there was nothing sworn. Obviously, Your Honor, just being in this division, is more familiar with out-of-state holds. I believe it was explained that really, that they can rely on teletype, and that's what's, my understanding is here. There's a teletype out-of-state warrant for these charges. Respectfully, Your Honor, I'm gonna ask, based on the court's own experience and knowledge of extradition,
Go ahead, I'm listening.
extradition issues, to find probable cause.
Okay. All right, court's gonna find probable cause. There are 2 out-of-state holds with a $100,000 bond and a $75,000 bond, so a total of 175. We are gonna see you, go ahead.
I'm sorry, I wasn't here either. I don't know exactly what was said. Well, from what Mr. Bradley was advised me, I believe in the past he's been picked up on these warrants before. They were not extraditable. It was for in-state pickup, and I believe that conversation came up with the judge, and based on that totality, that I believe the magistrate judge, from what I'm being informed by Mr. Bradley, didn't find probable cause and gave 48 hours time for perfect. So.
All right,
Judge.
here's the thing. When we're in extradition court, I know we have to put it on, the juvenile. So you don't get to view that, but one of the things that I clearly state is even if the requesting state doesn't come pick you up, that doesn't mean that the warrant's gone. So if he was released from custody because the state of California didn't want to pick him up, I specifically tell everybody, they are to resolve. They have to go back to the requesting state because they can be picked up over and over and over again. And this is gonna keep happening until he resolves. Every time he gets stopped, this warrant's gonna show up. So I do find probable cause. We'll see him in extradition court again. Maybe he wants to contact an attorney in California or whatever it is he wants to do. But he's gotta pay the $175,000 bond before he bonds out, before extradition court. Otherwise, it's just an extradition order, and he can't bond out after then. Thank you, sir. Good luck to you. Okay, Nathan Clifford. Here you go. And then we have Misty Elsner.
Mr. Elmer? Oh, no.
Why do I have that? Oh, defendant may travel back and forth. Okay. So then we have, what about Pedro Medina?
Oh, he's here. He was
Okay.
on recall. Come on, sir.
And then we'll do, last case in North Broward. Okay, Mr. Medina, so I read all your charges. State, what are you requesting on counts 1, the ones that are HG, the burglary, unoccupied conveyance, unarmed?
Yeah, Judge, I still don't see probable cause for 3 of the grand theft auto charges. I believe, if I recall correctly, having read the state's copy of the police reports, that Mr. Cabrera Medina was found to be in possession of 1 stolen car, but it looks as though the accusation is that he went into other cars and started them, but didn't steal them.
Well, all right, let's start one by one. He has a 2013 Infiniti. He pressed the start button. It says entered, press the ignition start to determine if the key fob was present.
Is that enough to say that he stole the car?
Your Honor, it's theft is either stealing or endeavoring to steal. Certainly, by his actions, an argument can be made for PC that he was endeavoring to steal the vehicle.
I must respectfully disagree. I think that in order to have
All
probable.
right, so what are you saying it is?
I think it's a trespass of a conveyance. And he's
you're-
already charged with burglary of the conveyance. I think it's a duplicitous charge. And starting a car and stealing a car, I would say, just from a common sense perspective, is not the same thing.
Your Honor, and Ms. Reedy had no response to my argument. The law states the definition of theft is to steal or to endeavor to steal. Essentially making an attempt to steal.
All right,
is a
I'm gonna
theft.
find probable cause on that, so let's go to the next one.
I would just state for the record that starting a car is not the same as endeavoring to steal the car.
Okay.
That's just, I mean,
No, I understand, I appreciate
and
it.
certainly the court can take that into consideration for purposes of bond as well.
Absolutely.
So I would maintain that objection to 3 of the grand theft auto charges.
All right, let's go to the next one. A 2016 BMW 528i.
I think we're talking the same
And
fact
then
pattern.
it says, defendant opened the unlocked door owned by the victim with the intent to commit the offense of motor vehicle. Stated he did not enter the vehicle, he only opened the door approximately an inch and closed it.
Even, Your Honor, stealing and then changing one's mind is still,
This is a BMW and a Dodge Challenger.
yeah, as far as the BMW, he opened the unlocked door and he closed it. He said he decided not to. Still taking the measures he took, that was a theft.
I just can't agree with that statement.
That doesn't surprise me, but.
And I'd ask the court not to agree with that statement. That's not theft.
You go in with the
You can go
intent to
in.
commit an offense and he's sitting in the car.
If I understand what you said correctly, Judge, and I gave back the copies of the reports to the state, but I did read them, and as I recall, I think you're right. He opens the door, then closes the door.
No, that's another car.
In the BMW, the defendant entered.
The
located the key and
BMW,
exited.
he enters it with the intent to commit grand theft auto. And then in the same PC, there's 2 of them. That's the BMW, then there's a 2018 Dodge Challenger. That's the one where, so we have the BMW one, just so you know.
Okay.
So
That's
then we
still
have
not
the
stealing
third
the
one,
car.
which is the Dodge Challenger, and it says he was going in it with the intent to commit the vehicle theft. The defendant stated he did not enter the vehicle, he only opened the door approximately 1 inch and closed it.
Oh, what do we have, the thought police finding probable cause now? I mean, that's not stealing.
Your Honor, right, first of all.
It says he confessed he was in Hibbs Grove for the purpose of stealing vehicles.
But not that
Defendant
one.
pointed out the BMW and Dodge Challenger as the vehicles that he was gonna be trying to steal, that he was there to steal.
Okay, so he thought about it.
Your Honor, it
It said-
requires an act and intent. Mr. Reedy can call it thought police, but it's called intent. And he had the intent, and he did commit an act. He opened the door, and then he changed his mind and closed it. But as long as he has the intent and some act in furtherance, that's endeavoring to steal.
I'm gonna find it on the Dodge as well, I'm sorry. Then he
Don't
has.
apologize, it's all right. You're not gonna hurt my feelings, Judge.
Okay, I don't wanna hurt your feelings, for sure. Then we have,
Then there should be one more.
he looked for unlocked high-end vehicles, I guess. One of the unlocked was a 2017 Infinity. Parked in the driveway, he intentionally entered the vehicle without the owner's consent by accessing the unlocked driver's door. While inside the vehicle, Pedro pressed the start button, which helped him confirm that there was a key fob in the vehicle. That's number 4.
Okay, and I make the same argument again. It's a burglary, but it's not a theft.
And this one even said he was gonna return later to steal the car.
Again, we have the thought police
It's
who are trying to figure out what it is that Mr.
There's
Cabrera
also one
Bavida
other
is
one, I
thinking.
believe. There's 5 grand thefts.
He went into the car, took the fob, and left with it. It wasn't
didn't
just
take the
his
fob.
thought.
Did he? Did he take the fob? Then it's a burglary.
Well,
Burglary with intent to commit
respectfully,
theft, and he committed the theft.
And then there's a capias,
Well, I don't have any argument on that.
18-010-0471. So the court's gonna find probable cause on all counts. What say you, state?
Your Honor, state's asking for $1,000 on each count.
Okay. Defense?
Judge, $9,025, he's simply not gonna be able to afford. He's 18 years old. Right now, he is working, he works for, the shop is called Good Body Shop. He's been there for about 2 years, making about $80 a day. Besides that, he goes to Hallandale Adult. He's pursuing his high school diploma. He goes there, Monday through Friday, from 9 a.m. to 5 p.m. He lives in Miramar with his mother. His mother works at a hotel in their cleaning department. So funds are limited. He believes that maybe his mother can come up with $200, the premium with using a bond service. So I'd ask Your Honor to consider a $1,000 bond on one, $1,000 bond on count two, ROR the rest of the counts, and also have them supervised on pretrial release.
All right, this is the issue. He was driving a 2016 Cadillac on May 10, 2018. He was charged with operating without a valid DL, no car insurance, and failing to stop for a school bus. He didn't show up for court.
That vehicle is not his, Judge.
All right, but he didn't show up for court, so what gives me confidence for an operating without a valid license? And he's running around in, this Cooper City area with all these cars. I mean, what gives me confidence that he's gonna show up and not commit other crimes? I can tell you one thing I am gonna do is do a GPS level 2, and I am doing a curfew. But it's a matter of the bonds. What's his prior history, and then I'll let you speak.
Your Honor, he hit a loitering and prowling a few months ago. In Dade County.
Okay, all right, go ahead, Mr. Romero, I'm sorry.
Judge, on the misdemeanor capias, he simply told me that he didn't receive notice for it. Now, these are obviously much more serious. He's probably gonna take a more of a responsible role as far as determining when his court dates are. He'll be also supervised by pretrial. That would be given an additional way of him learning when's his future court dates, help him keep him on track. So I believe a $2,000 total bond with pretrial release would be reasonable, Judge. And Judge, if Your Honor is considering a heightened level of supervision, then I'd ask you as far as an outright ROR, as far as a monetary bond, with the additional level of pretrial release.
Does he have a US passport? Says he's a citizen, or he was born in the Dominican Republic. I don't know how long he's lived here, but.
Judge, he's been here for the past 8 years, so he's been here since he was 10 years old.
Okay.
All he knows is this community.
Okay. Does he have a US passport?
Judge, he's not sure. He doesn't know if maybe when he was 10, his parents try and get him a passport. He doesn't know.
Does he have a Dominican, does he know if he has a passport from anywhere in the world?
Judge, he's trying to the best of his ability to recall. He's never traveled outside the U.S. since he was 10 years old. He doesn't know. Logically, he says in order to come here, he probably had a Dominican passport, but that he's never seen, so most likely it's expired. But so that's why he's kind of confused. He doesn't know as far as his passport situation.
What's his address, where he lives?
Let the judge know your address.
6118 Southwest 21st Street, Miramar, Florida. Oh, 33023.
Your client, did you say he goes to school?
He goes to Hallandale Adult from Monday through Friday from 9 a.m. to 5 p.m.
Does he work?
He works at. Oh, you work from. I'm sorry, Judge. You work from 9 to 5. Good at that Good Body Shop.
Yes, sir.
And what days do you go to school?
I go Thursday. Wednesday and Friday.
Thursday. So 7 p.m. to 9 p.m. Okay. So that was your job. But I'm sorry, Judge. When I wrote it down my notes, I got confused. He works full time 9 to 5 at Good Body Shop, and then only 3 days a week he goes to school: Wednesday, Thursday, and Friday from 7 p.m. to 9 p.m.
Where's his Where's his business? Where's the place he works? What town?
Where's the job?
That's West Park.
West Park, which is I guess next to Hollywood, north of Hallandale.
And where does he go to school? What town?
Hallandale Adult, which is in Hallandale, I believe.
No, that's a Miramar.
Oh, that's in Miramar?
Yes, they moved it. They relocated.
Miramar, but he's advised, Coach.
What time does he have to be at work?
9 a.m.
All right, court's gonna set $1,000 bond on one, $1,000 bond on two. Court's gonna set $1,000 bond on three, $1,000 bond on four, and $1,000 bond on five. On 6, 7, 8, 9, court's gonna ROR him. The capias, I'm gonna set at $100 bond. He's to show up and figure out what's going on with that. It's his responsibility. You can explain it to him. So the total is $5,000 in bond. Six, 7, 8, okay. GPS level 2, he has a curfew from 7 p.m. to 7 a.m. I am gonna allow him to go to school. I'm gonna allow him 1 hour to return. If it goes outside the curfew time frame, he's to show his schedule to pretrial services. He's not to return to Hibbs Grove, and I want him maintaining 1,000 feet minimum at all times. There's no victim contact with any of the alleged victims in the case, whose initials are CJR, DAT, JB, NN. I don't know what the one is in the Judge Usan case. Oh, it's State Farm. It's another one. All right, sir, thank you. Good luck to you. GPS level 2, but I am allowing him, obviously, if he has a curfew from 7 p.m. to 7 a.m., if his school goes, he said he goes to school from 7 to 9, I believe. As long as he shows you proof, he's allowed, but he has to be home within an hour.
And Your Honor is putting him on pretrial on both of the felonies.
All the counts, yep,
Thank you.
except for the capias, obviously not that one.
Just the two felonies.
Yeah, all counts 1 through 8, or what is it? How many counts are there, not including the capias, Madam Clerk?
8, Judge?
8 counts, thank you.
I'm sorry, you're exceeding 1 is the case.
Okay, 9. All right, Counselor, come on up. Let's go back to North Broward. I need my paperwork back. Mr. Reedy can give you an extra copy if you need it.
Actually, I don't, Judge. All I've got, I do have a probable cause affidavit.
Okay. All right, so let's get Mr. McPhee back. Alan McPhee. North Broward, thank you. I see Clervis back, just the top sheet? Jaheel Clervis. Okay, Mr. McPhee, do you see your attorney here today?
I did.
All right, Mr. Amoroso, nice to see you. Please announce your appearance for the record.
Thank you, Your Honor. A.J. Amoroso on behalf of Alan McPhee.
All right, we have driving while license is suspended, third or subsequent offense, $750 bond. He has 5 prior convictions for driving while license is suspended. State, is his license suspended for any alcohol or drug-related activity?
I believe so, Judge.
Do we have a driver's license on him?
While you're looking, I can tell you, he had a felony DUI, or from my conversation with Mr. Amoroso, at a minimum, it was suspended until very recently for DUI. 2010, he had a felony DUI and a felony DWLS. It was dismissed in 2016 through mental health court. He had a felony DUI conviction from 06, another DUI in 03, and I believe other DUIs that were dated. Do you have his driving record, Judge?
I just got it.
Okay.
All right, so what say you, Mr. Amoroso?
Judge, I know you're taking a look at that record, and believe it or not, Alan is under the impression that he is eligible for a full-fledged regular license. In fact, Judge, I can tell you, and I'm taking Alan's representations for this, because we communicate on basically a daily basis. He's one of my high-maintenance clients, so to speak. Judge, he spent the weekend, including Friday, doing DUI class. And I believe he completed it. He was going to get the last text I received. He was going to get a certificate this coming Wednesday. And then it appears that the only other obstacle he would have had in his way was to put an ignition interlock device on this vehicle that is registered and insured to him. Judge, I can tell you this. He is on disability. As you can see, he can barely walk. I know he's going through some financial hardships right now, in the sense that he paid a lot of money for the DUI school, which he had to reschedule a couple of times, as well as, according to the last text anyway, I think his water heater broke down yesterday. Is that right, Alan?
Yes, it did.
Judge, he has no family local. He owns a home. He doesn't have any family. He doesn't have any friends. I'm the closest friend he has. Judge, I'm asking the court if the court would consider, in this particular case, relying, instead of a monetary bond, on pretrial services. And hopefully, if he gets his license straightened out and within a couple of weeks, we'll do whatever we need to go and do in court.
His last DUI was when, 2006 state? He's had like a lifetime, though, of
I know, Judge, that's why
driving offenses while under the influence, I mean.
Judge, and that's why I'm telling you is I don't believe it, but he has been told by the DUI school and the DMV that he is going to be eligible for either a full-fledged license or some kind of restricted license. However, he's going to be monitored by them, and he's going to have to put an interlock device on that vehicle.
State?
Really, my greatest concern is why they're going to be putting a device on his car, on the car's registration. This does involve a crash.
But here's the thing, and I'm not, if it wasn't alcohol related and it was a crash, I mean, he didn't flee from the scene, it doesn't appear. I don't see any information of that. Just because you don't have your driver's license doesn't mean that you caused the crash or it was his fault. I mean, another person could have came running into him, and I understand what you're saying, he shouldn't be driving. The court's gonna order for him not to be driving. But he can't afford any bond?
Doubt it, Judge. Plus, it appears that his vehicle got towed, and I mean, the vehicle should be the least of his concerns, but he's gonna have to come up with some money to do that.
Now, the only thing I can do is this, and I'm gonna I'll lower the bond, however, I am gonna order no driving until further order of the court. I don't think that there's any way that I can do an interlock device, is there? Is that administrative?
Judge, the DMV is gonna require it of him, so there's nothing you.
Well, I'm gonna put no driving until further order of the court. He's to have a TAD monitor, random testing. Prescription meds, no alcohol or intoxicants, which he's not allowed to have anyway. Prescription medications are allowed as prescribed. You can talk to pretrial services about waiving the costs or the cost of the TAD monitor. And I'll do a $250 bond. But I am gonna put him on standard pretrial supervision. I am gonna have him call in twice a week. Report one time a month in person. Random testing is at his expense. You know what? I'm not gonna require a bond. I don't think $250 is gonna make a difference whether he does something or not. And I don't think $750 if he had the ability to pay the bond. I think these are a lot of restrictions. This is the most I can do to protect the community. So, at this point in time,
So Judge, even if he obtains some type of driver's license, he is not to drive
no, I want him to go
until a
before his
court.
division judge.
Yes, ma'am.
Okay? All right, thank you, sir. Good luck to you.
Thank you,
You have to
Judge.
report within 24 hours.
Got that?
Thank you, of your release. Deputy at North Broward, can you give Mr., is it McPhee?
Yes.
Mr.
He has
McPhee a
one.
map?
He has one.
All right, sir, you have to report within 24 hours. Good luck to you.
I have to come back here.
No, you have to go to pretrial services,
Oh, okay, very good.
which is, sir,
Downtown.
hold on, which is right by the main jail and the main courthouse. So if you don't go there within 24 hours of your release,
I'll go there. Immediately I'll go, immediately.
if he doesn't go there, he's gonna have a warrant out.
Oh, I'm gonna go immediately, ma'am.
Okay, good. Thank you, sir. Good luck to you.
Thank you, Judge.
You're welcome. Have a good day.